Hello, it's lovely to see you all at this Procurement Bill webinar. I'm going to talk today about some of the changes in the Procurement Bill, which will be of particular interest to the HE sector. If we could go on to the next slide, please. I'll also update you on the progress of the bill throughout Parliament and the main themes of the amendments. And whilst the implementation of the procurement regime is still some way off, there's a number of things that you can be doing now. So I'll cover this at the end of the talk. Just a reminder that obviously the bill is still going through Parliament. So whilst my comments reflect the current state of the bill, it may change with amendments. So just a reminder of the main aims of the bill and an overview very quickly, because the transforming public procurement agenda has been around for a while and many of you will be familiar with it. The procurement bill, the next slide please, consolidates the public contracts regulations, the concession contracts regulations, utilities contracts regulations, and the defence and security regulations. The stated government aims of the bill are to speed up and simplify procurement processes, to place value for money at their heart, and to provide greater access for SMEs and social enterprises, and to innovate public service delivery. The Public Procurement Bill is easier to read. There has been some tweaking of the languages for political purposes, but some of the concepts remain the same. Getting a lot more flexible processes. I think those come from the utilities regime, but those are balanced against having greater transparency. The bill also takes the opportunity to introduce clauses on contract management to improve public contracting. Just a note, in terms of the application to devolve regions, we've got a number of delegates who are from Wales, and I believe a delegate also from Scotland. So in Wales, the procurement bill will apply, but some of the supplementary legislation and guidance will be different. So, for example, Wales has its own procurement policy statement, and they are just in the process of passing a social partnership and public procurement Wales bill. Scotland are keeping their own procurement regime for the moment and will not be applying the procurement bill. On the next slide, I just want to make a few comments about the layout of the bill and its interpretation, because this is very different. So there are 116 provisions in the procurement bill, and that compares with 121 in the public contracts regulations and 11 schedules. So the schedules contain a lot of the details about definitions, about exemptions from the bill, direct award justifications, and mandatory and discretionary exclusion grounds. Because there's been so much crammed into it to make, and it is only 116 provisions, it is light on detail compared with the PCR. For example, the rules on calculating thresholds aren't nearly as detailed as they are in the PCR. The bill will be supplemented by additional statutory guidance and legislation. So, for example, the National Procurement Policy Statements, other BPNs. So you'll have to read the bill alongside the additional guidance and legislation and make sure that you're up to date. So the language of the bill is very different, and it's a lawyer's point, but there's going to be a mind shift in interpreting the bill. Next slide, please. It is clearer and a lot simpler language. One of the points that I've noticed is that there's a frequent use of drafting in the negative as a general principle, and then you've got exceptions below. So I actually sometimes feel that's quite difficult to read, and so you get the issue about double negatives. So for clause 10, which is a key clause about the application of the bill, it says a contracting authority may not carry out a procurement except in accordance with this act. I suppose I do have a concern that this emphasises the negative and reinforces perhaps the stereotype that procurement is a blocker. There is some confusing language for those of us who've been around for a while. So, for example, the well-known contract award notice, which is under the PCR, published once a contract is awarded. Under the Procurement Bill, the contract award notice refers to an intention to award a contract. So there's getting some head round some of these new concepts. I think there's going to be some further guidance on interpretation, but because some of the concepts have been sort of pared down to the minimum, there is an issue about whether some of the sort of EU interpretation will continue to apply. And a good example of this is in relation to the definition of a contracting authority. The bill takes away the language of an organisation set up in the public interest. So there is some scope for uncertainty regarding interpretation. On the next slide, please. I just wanted to set out the new principles and objectives because, again, these are new principles that have moved away from the EU general principles of fairness, transparency, and non-discrimination. So there are 4 underlying principles which contracting authorities have to have regard to when they're applying the procurement rules. So to act with integrity, to ensure value for money, to act in the public good, and equal treatment has been replaced by the concept of fair treatment of suppliers, which means that suppliers should be treated the same unless there's a reason for different treatment. And if there is a reason for different treatment, then the contracting authority must take all reasonable steps to ensure that it doesn't put a supplier at an unfair advantage or disadvantage. Now, the concepts of proportionality and transparency no longer underpin the rules, but they're used in the specific context of the bill. So, for example, when you're designing award criteria or when you're designing your own process, you have to have regard to the principle of proportionality. And of course, transparency, there are a whole load of obligations to come to in relation to making sure that procurement processes are transparent. And then also outside of those principles, you've got the the Welsh procurement policy statements. So just on the next slide, I want to look at the scope of the bill. I mentioned previously the definition of a contracting authority. So, question where universities are called. So, public authorities are subject to the bill where they have functions of a public nature and where an organisation is funded wholly or mainly from public funds or subject to contracting authority oversight. Now, whilst universities clearly have functions of a public nature, so for example, education and research, a lot will have aspects of a more commercial nature. Seems to me that universities sit better under the definition of a public undertaking in the bill, but that's actually been reserved for utilities. So I think it's useful to have further guidance on this aspect. I think one of the useful clarifications in the bill is, however, that when you're looking at deciding whether you're funded wholly or mainly from public funds, you can disregard funding which has come from a public source, but where it's in remuneration for goods, services, or works. So that's a really useful principle for those universities which consider that they're outside the scope of the procurement rules or are looking to decide whether they want to fall outside the scope of the procurement rules. Next slide, please. So there are just some tweaks in terms of what is caught under the procurement bill. So work, services and supplies. As part of the consultation and response, the government have said that they will include light touch resumed services still. It's not clear whether the full range of light touch services will be included. So, for example, education, concessions included, and framework agreements are going to also, they're included as part of the bill. Now, in terms of exemptions, they're very familiar, they'll be very familiar to you all, but I think there is a useful tweak for research and development services. Next slide, please. So previously, research and development services were excluded from the scope of the bill, but only where they were limited to contracts which were wholly funded by contracting authorities. So if there was a grant, the universities received a grant for research and development services, then it fell outside the scope. It didn't meet the grounds for exclusion. But now there's a useful clarification of what is deemed to be research and development services, which includes prototypes. So it includes the use of prototypes to develop learning. The only exclusion is that there cannot be commercialization as part of the contract. I'm going to talk about research and development services because there's an interesting correlation. Research and development services are in part excluded, but later on they're also subject to direct award, and it's not quite clear to me at the moment where the interface between the two of them lies. Just on the next slide, please, a quick reminder of the processes and routes. So I've mentioned already that Regulation 10 says that procurement can only be carried out in accordance with this Act, and it states the grounds for procurement, which can either be by competitive tender, by the use of frameworks and dynamic markets. I've added dynamic markets in brackets because Regulation 10 doesn't explicitly refer to dynamic markets, but that must be the case, it includes it. And then there's some exclusions, also there's some grounds for using direct award. So the competitive tender, the processes have been reduced from 6 processes just to 2, either the open procedure or I've called it the build your own or the design your own competitive route. And in terms of direct award, there are a couple of useful grounds for universities. So I mentioned prototypes and development. So there's a ground for direct award for prototypes and novel goods or services designed or developed at the request of the contracting authority. I think this is intended to replace the old innovation route. But as I say, it's not quite clear when you can have direct award under the bill where it's actually excluded, or where prototypes and services are excluded under the research and development exclusion. So the advantages of the new bill in terms of processes and routes, there's much less, there's a great more deal of flexibility in the design your own route as to how you build that. So for example, there's a possibility of refining award criteria as you go through the process. There are some safeguards that are involved. Use of demos, which I think would be particularly useful for IT procurement, but it was never expressly clear whether demos could be part of the award process. And obviously there's the ability to carry out structured negotiation. So just turning now to some of the areas which there have been quite a lot of changes, and why they're useful to know in the context of the HE sector. There's been a greater focus on supplier behaviour. So universities must take reasonable steps to identify and keep under review actual or potential conflicts of interest, and all contracting authorities must carry out a conflicts assessment prior to going out to tender, and to keep it up to date throughout the process. Personally, I'm in favour of this provision because it's much easier to deal with conflicts before they arise. And whilst I think contracting authorities are very good at carrying out conflicts assessment as part of evaluation, often conflicts can arise much earlier. For example, if you use a consultant to help with designing specifications, and sometimes there's issues about associated companies trying to bid for that work, or sometimes I've been involved in cases where bidder teams from suppliers involve previous members of staff. So the exclusionary framework has been widened quite considerably. So the grounds for excluding a supplier, both under the mandatory and discretionary grounds, have been extended to associated suppliers who might be part of a consortium, for example, and to subcontractors. But if a university wants to extend those grounds to a subcontractor, it needs to specify that in the tender information. So there are also some new grounds for exclusion. For example, improper behaviour, and that applies throughout the procurement process. So, for example, if you have a supplier who tries to get advantageous access to members of academic staff, or for failing to provide information, often there's an issue with an incumbent supplier who's asked to provide information about 2P for a procurement and just is quite slow in providing that information. There's been a lot of talk about the introduction of a debarment list, but to central government and some of the devolved authorities are able to propose that a supplier is added to the debarment list, but only where an investigation has been carried out to decide if the supplier is an excluded supplier
or an excludable supplier. So those are when you have an excluded supplier when they have to be when they would fall within a mandatory ground for exclusion. Excludable refers to where there's a discretionary ground for exclusion. There's also some very helpful clarification on self-cleaning and when a supplier will have done enough to ensure that its exclusionary grounds should no longer apply. So on the next slide, please. There's been a lot of talk about changes to frameworks and dynamic markets to make them more accessible and to sort of bring them up to date. My experience is that procurement under frameworks is always more complex than you think, and interestingly, there have been a lot more cases recently and challenges in this area. I think my view is that the rules have been tweaked in relation to frameworks and dynamic markets, but they're perhaps not as radical as originally proposed. So with regard to frameworks, there's a tightening up on the rules on direct award. So where you have got more than one supplier on a framework, the process for calling off under a contract for direct award and the terms must be very clear. Compared with the PCR, the detail about frameworks and how they will operate is also quite light on detail and maybe an area that there's going to be further guidance on. The concept of an open framework is that a framework can, in some circumstances, apply for a period of up to 8 years instead of the 4 years current restriction, but with a requirement that at the end of year 3, it's opened up to the market again. But my take on it is that actually the amount of work that is involved in opening up the framework to new competition and the requirement for existing suppliers to rebid, I'm not quite sure how much saving there is on work compared with starting out a new competition. And in addition, you can't make any changes to the original framework. I think dynamic markets, a lot of the concepts that have been used for utilities in relation to pre-qualification systems have been applied. So now a university could say we're only going to award contracts for a particular type of services or goods contracts to those on a dynamic list. The requirement for electronic processes seems to have been dropped. And what I think is really useful is that one of the limitations about the old dynamic purchasing system was that every time somebody wanted to be admitted to the system, a contracting authority, university, had to admit that supplier within a period of 10 days, which was pretty tight. And that has now been changed to there's a requirement to admit a supplier if they pass the minimum standards to the period must be reasonable. So it's a lot less prescriptive. Moving on now to one of the big changes in terms of the number of notices that need to be required during the life cycle of a procurement process. And this is, I think this has been one of the concerns being raised by university in particular about the resource required to publish all these notices. So while the number of routes to market has been reduced, the number of notices has been increased. So I think there are 11 different types of notices that I've actually counted. So just to talk you through some of these, the pipeline notice is going to be equivalent to, I suppose, the PIN notices,
at the beginning of each year, but that only applies where a university thinks that it's going to be procuring goods or services or works in excess of 100 million, and the notice to publish only applies if for contracts with a value over 2 million. So the planned procurement notice takes the place of a PIN and has the advantage of reducing tendering periods. If you decide to carry out market engagement, then you are then required, it's a mandatory requirement to publish a pre-market engagement notice. So the contract notice, as was, will become the tender notice. And then there's a bit of relief from publishing notices until you get to the award stage. So we'll come on to this in a minute. Before you award a contract, you have to publish a contract award notice. And then once you've awarded the contract, you have to publish the contract details notice. So the contract details notice is where you have to publish the full details of the contract. But this only applies to contracts above 2 million. There are other number of notices. I haven't on this list, I haven't mentioned, it isn't there, but actually if you decide to abandon a procurement halfway through a process, you have to publish a procurement termination notice. There are payments compliance notices. So this is required to set out compliance with the 30-day payment terms. The contract termination notice, so where you intend to terminate a contract, that must be published within 30 days of the date of contract termination. Also on this list is the transparency notice, so where you're using a direct award and obviously not going through a procurement process, then you must set out the intent to use a direct award procedure. There are limited exceptions for not having to do that, where for reasons of urgency or to protect life. Okay, so going on to the next slide, which is transparency. So I mentioned that the bill takes the opportunity to include some new contract management provisions. So there are applied terms about electronic invoicing and payment on time, and some of those apply to below threshold tenders as well. So where you've got contracts above 2 million, there are some additional requirements. So currently the requirements is that the contracts have to contain a minimum of 3 KPIs. As mentioned, there was a requirement to publish the contract, and any modified contract. So before, the obligation to, or currently the obligation to publish contracts only applies to central government, but this is being extended to all contracting authorities. And I know that I've had a number of questions from universities about whether or what type of information you can withhold under for commercially sensitive information, for example. Now I'm working with a colleague to look into this in a bit more detail, and we're due to speak in an event on this next month. So I'm hoping to produce an article or to do another seminar. If this is an area that you're particularly interested in, please let me know. So on the next slide, I just wanted to flag up the changes to the standstill. While the remedies or the legal remedies are not going to change significantly, there is an important change to the standstill period. So the standstill letter, as is going to be replaced with an assessment summary. So my understanding of the assessment summary is that unsuccessful billers will be provided with their own individual evaluation document, and then they'll get the evaluation document for the successful bidder, but with redactions. But in addition, the contract award notice must be published prior to the contract award. So that means that before you can issue, before you can proceed to contract, you have to comply with the assessment summaries and you have to issue the contract award notice. So the calculation of standstill periods, there's been a revision to the time period for calculating those, which I think is eminently sensible, because it stops the situation where you count your 10 days and then have to work out whether it's on a non-working day and extended. So that is now revised to 8 working days, beginning with the day on which a contract award notice is published. There's also a change in that the automatic suspension, the right for a complainant to claim automatic suspension by issuing legal proceedings, only applies if a claim is brought during the standstill period. However, whilst on the face of it that looks like they have less time, the fact that they have the standstill letter or the assessment summary has to be issued and the contract notice published actually means that the complainant is going to have a longer period of time, I think, to be able to decide whether or not there's been an issue with the procurement and decide whether to issue. Moving now to the amendments, there have been an awful lot of amendments to the bill as it's been going through the House of Lords, and I thought I'd just try and give you a summary of some of the themes. The government recognised fairly early on that the procurement bill that was published didn't properly address the TECL exemption where there's public contracts. So my understanding is that is being looked at to make sure that it works and reflects the current EU position. I talked about the design your own procedure. It is now proposed to call that procedure the competitive flexible procedure, and that so the references to this procedure would be changed throughout the bill. The grounds for exclusion, there's been a lot of debate about making sure that because exclusion is has obviously a significant detrimental effect to suppliers, that they have a right to be heard and to appeal. There's also been quite a lot of discussion about contract management and whether KPIs, there should always be 3, or whether there should be other forms of measurement if KPIs are not always practical. There is an updated version of the bill which has just been made available on the Parliament website. We've actually managed to do a compare version of the latest version of the bill against the bill as was published. I'm not sure that it's 100% accurate, but it gives you a pretty good view of the changes. If anybody liked to have a look at that or get the hold of that copy, then again, please let me know. So where are we now then in terms of the bill? Moving on to the next slide, please. So the procurement bill is progressing in the House of Lords. It's just completed the detailed line-by-line scrutiny of the bill in the committee stage. I had a look at the Parliament website this morning. I was still waiting for a date for the next stage, which is the report stage. So after the report stage in the House of Lords, it would go on to the third reading in the House of Lords and then transfer to the House of Commons for review. Now, it's taken 6 months to get this far. I know there's been a slight hiatus over the summer, and there has been a change in the ministerial team leading the procurement bill. So hopefully the procurement bill sort of should progress at normal speed now. But once it gets to Royal Assent, we've been promised by Cabinet Office a minimum of 6 months before the go-live date to allow for learning and development to take place and for issuing of statutory guidance. So on the next slide, just for a bit of fun, I'd just be interested to have your predictions about when you actually expect the procurement bill to come into force. We did this at the last one of the updates that I did for HE earlier in the year, and I think the overwhelming vote at that stage was for the expectation that the bill would be available or the act would be implemented in October 2023. I'm interested to see whether that's changed. We got the results of the poll. Yeah, it has changed quite a lot. So 63% say early 2024. December 2023 has got 26%. I have to say I agree that it definitely looks like the end of next year, and given what we've had with the Subsidy Control Act, which was promised in autumn but is now being implemented in January 2023, I can see that January 24 looks like a safe bet. Thank you very much for that. So although, as we can see, the implementation period still looks a long way ahead, are there things that you can do to get ready? I think there are a number of things. I think some of the easy wins are putting in place conflict assessments, so that if you haven't already got conflict assessments throughout, from the beginning to the end of a process, I think that's something to look at. Evaluation. So I mentioned as part of the discussion about standstill, as part of the assessment summary, there's an expectation that the evaluation matrices are going to be made available to suppliers. And therefore, I think it's a really worthwhile time to look at your evaluation matrices and see whether they are in a form that you feel would be able to be disclosed to suppliers, albeit that there may need to be some reductions where you're thinking about disclosing to in relation to the successful supplier. One of the issues under the bill is that I think it's going to take away quite a lot of the risk management decisions that universities often have to take in terms of making modifications to a contract, and whether you think that whether you think it's a material modification, or whether actually there might be commercial reasons for making modifications, and saying, well, you might accept some risk of a procurement challenge. And I think the transparency rules mean that it's going to be much more difficult to make a risk-based assessment of procurement decisions. So therefore, there's an argument about thinking about what contracts have you got now, and whether or not you decide to extend or modify or make changes under the existing regime. I think certainly identify a list of contracts above 2 million, where there will be greater contract management requirements and requirements for KPIs. We've talked about resourcing in terms of, obviously there's going to be a big or a significant time in getting up to speed and then implementing all these additional notices. Government have talked a lot about their learning development schemes, and they're saying in the recent update it's useful to have an idea about what the demand is going to be for the different types of learning development, the e-learning or the intensive drops, and I think there's a possibility of signing up to those courses. Government have also recently issued a checklist about things that you can do to get ready. So on the next slide, I have just made some concluding comments on the bill so far. The flexibility, the increased flexibility, I think has to be welcomed. And also has the way that the bill has been drafted means that there's less risk of gold plating if there ever was a thing. The bill addresses a number of practical issues that I think contracting authorities, when you get a situation about exclusions and whether you can self-clean, whether a supplier can self-clean, and how to deal with conflicts assessments, is really useful, because there are sort of issues that have arisen, and I think the bill provides answers to those. As I mentioned, I think there's less discretion. The increased flexibility comes at a price, which is there's less discretion as to how you manage risk under procurement. And finally, as many of you who have attended my webinars before will always note that I tend to finish on making sure that you've got a detailed audit trail, but I think it, particularly in this case, given everything's new and the need for transparency, that point about having an audit trail to justify your decisions is reinforced. So I think we've got time for some questions, and I welcome any questions or comments at all on the bill. Right, so a couple of questions that have come in. The contract value of 2 million, is that an aggregated value over the duration of the contract? So my understanding, and I can check this point, is that 2 million is the estimated value of the contract at the start of the procurement process. So it should include the duration of the contract. I suppose there's a question, isn't there, about whether you've got options and whether that's included. I can have a look at that in a bit more detail and come back on that. So is there a replacement for VEET notices? Good question. I think the answer to that is that there's no longer a need for VEET notices because of the requirement to issue I'm just checking that I've got the right name. I think because the requirement to issue a contract award notice, which is the intention to award a contract, so I think feat notices will fall away. Right. Okay. So the comment upon the interrelationship with direct awards relating to research. Is it my view that the provisions on research are intended to be different to the current provisions for exclusions of direct awards relating to research? My view is that they're intended to be a lot wider, actually. If you look at the text, they are intended to go beyond what the current provisions under the PCR are in relation to research. This is it. I'm not quite clear when you can have when you say that something's excluded, or when you say actually it's not excluded, but I can award it through direct award. That to me is not yet clear. So we've still got time for a few more questions. Yeah, so there's a question about below threshold contracts and reserve contracts by geographical area. That's correct. One of the recent public policy notices said that for below threshold contracts, it's possible to reserve contracts in particular areas. So that is currently in force. What I would say, if anybody has got any feedback in terms of how you would like to be kept updated on the procurement bill over the next year, whether it's by articles or mini webinars or sort of larger webinars, then I'd be very pleased to receive that feedback so that we can structure our training accordingly. Right, there's a question just come through on the chat, which I think is available for everybody to see. Yeah, I'm just trying to follow the line of thinking there. I think this is a point about if you have a partnership type arrangement, whether there's a risk that it could fall within the definition of being a service. I don't think there's any change from what I've seen from the procurement bill in terms of the definitions of service. So it seems to me that that isn't an aspect that's being picked up necessarily by the bill. But if I have any more thoughts on that, I'll come back to you. A few more questions coming in. Okay. Yeah, there's the question that I have been asked about guidance on what information you can exclude when publishing bidder responses under contract detail notices. That is something that we're looking at. I'm working with one of my data protection colleagues on this area. So we are intending to provide some guidance on that aspect, because I know that's a question that has been asked by a number of you in terms of what information can effectively withhold under the contract detail notice.